Mesdames et Messieurs, bonjour. Je vous souhaite la bienvenue à cette séance au nom du tribunal administratif de l'Organisation internationale du travail. J'ai l'honneur, en ma qualité de président de cette Cour, de prononcer la deuxième partie des jugements rendus lors de la 123e session qui s'est tenue du 17 octobre au 11 novembre 2016, c'est-à-dire 93 jugements. Les 7 juges du tribunal ont participé à la session, c'est-à-dire le vice-président Barbagallo, la juge Hansen, le juge Friedman, le juge Moore, le juge Rollins, la juge Diakité, ainsi que Claude Rouiller qui vous parle. Au cours de cette session, le tribunal a examiné au total 113 affaires. Il a rendu 97 jugements qui concernent 21 organisations internationales. Il a pris acte de 8 désistements. Comme vous le savez, 4 jugements adoptés au cours de cette session ont été prononcés le 30 novembre 2016. Le tribunal note avec satisfaction que l'Organisation européenne des brevets a déjà pris des mesures spécifiques pour mettre en œuvre, en ce qui la concerne, ce que le tribunal a ordonné dans 2 de ses jugements. Le tribunal saisit l'occasion d'attirer votre attention sur un jugement de la Cour suprême des Pays-Bas du 20 janvier 2017 qui a préservé l'intégralité du système de recours de l'OEB et le rôle du tribunal dans ce contexte. J'annoncerai maintenant les 93 décisions du tribunal par ordre numérique une fois que le greffier aura lu un résumé de chaque affaire. Ladies and gentlemen, good afternoon. I have the pleasure of welcoming you to this meeting. As President of the Administrative Tribunal of the International Labour Organization, I have the honor of delivering the second part of the judgments which the Tribunal adopted as its 123rd session held from 17 October to 11 November 2016, which consists of 93 judgments. All 7 judges of the tribunal participated in the session. Vice President Barbagallo, Judge Hansen, Judge Friedman, Judge Moore, Judge Rollins, Judge Diakité, and myself, Claude Rouiller. During this session, the tribunal examined a total of 113 cases. It adopted 97 judgments concerning 21 international organizations. The tribunal recorded 8 withdrawals. As you know, 4 judgments were delivered in public on 30 November 2016. The tribunal notes with satisfaction that the European Patent Organization has already taken specific measures to address the orders contained in the 2 judgments that concern this organization. I will also take this opportunity to bring to your attention a recent judgment of the Supreme Court of the Netherlands dated 20 January 2017, which upheld the integrity of the appeals mechanism of the EPO and the tribunal's role in it. I shall now deliver the remaining 93 judgments of the tribunal in numerical order. The Registrar, Mr. Petrovic, will read a short summary of each case.
Le Centre technique de coopération agricole et rurale, CTA, a formé un recours en révision du jugement 3436, rendu suite à la requête déposée par Mme Omi Chiari sont irrécevables dans le cadre d'un recours en révision et que le recours n'a été introduit que pour tenter de réouvrir le débat sur des questions déjà tranchées dans le jugement 3436. Madame Ndiaye, qui a été contrainte à prendre part à la présente procédure pour défendre ses intérêts face au centre, a droit aux dépens.
Pour les motifs exposés dans le jugement 3718, le tribunal décide ce qui suit. Le recours en révision du CTA est rejeté. Le centre versera à la défenderesse la somme de 2 500 € à titre de dépens. Le surplus des conclusions de la défenderesse est rejeté.
Le Centre technique de coopération agricole et rurale CTA a formé un recours en révision du jugement 3437, rendu suite à la requête déposée par M. Ibrahim Tiemogo. Dans le jugement en question, le tribunal avait annulé la décision portant résiliation de l'engagement de l'intéressé et ordonné sa réintégration avec toute conséquence de droit. Le CTA demande au tribunal de revenir sur les conclusions auxquelles il est parvenu dans ce jugement. Le tribunal, qui a suivi le même raisonnement que dans l'affaire précédente, estime qu'aucun des moyens invoqués par CTA n'est de nature à justifier la révision demandée.
Pour les motifs exposés dans le jugement 3719, le tribunal décide ce qui suit. Le recours en révision du CTA est rejeté. Le centre versera au défendeur la somme de 2 500 € à titre de dépens. Le surplus des conclusions du défendeur est rejeté.
Monsieur Joël Bastier a formé un recours en révision du jugement 3510 contre l'Organisation européenne des brevets, OEB. Le tribunal rappelle que ces jugements ont l'autorité de la chose jugée et ne peuvent être révisés que dans des cas exceptionnels. En l'espèce, le tribunal considère que les moyens avancés par le requérant ne sont manifestement pas de nature à justifier la révision du jugement 3510.
Pour les motifs exposés dans le jugement 3720, le tribunal rejette le recours en révision conformément à la procédure sommaire prévue à l'article 7 de son règlement.
Monsieur Philippe Dedekind a formé un recours en révision du jugement 3681 contre le Fonds mondial de la lutte contre le sida, la tuberculose et le paludisme. Le tribunal rappelle que ces jugements sont définitifs, sans appel et revêtus de l'autorité de la chose jugée. Ils ne peuvent faire l'objet d'une révision que dans des cas exceptionnels et pour des motifs strictement limités. Dans le cas d'espèce, le tribunal considère que les moyens invoqués par le requérant sont dénués de pertinence et que l'introduction de recours ne constitue qu'une tentative de réouvrir le débat sur des questions déjà tranchées dans le jugement 3681.
Pour les motifs exposés dans le jugement 3721, le tribunal rejette le recours en révision en application de la procédure sommaire prévue à l'article 7 de son règlement.
Mr. Pradep Diwan has filed an application for review of Judgment 3583 against the World Health Organization. In that judgment, the tribunal dismissed the complainant's third complaint for failure to exhaust the internal means of redress. The complainant now contends that there was a material error and that the tribunal failed to take into account essential facts. However, the tribunal considers that none of the complainant's alleged grounds of review gives rise to reconsideration of the decision taken in Judgment 3583.
For the reasons explained in Judgment 3722, the tribunal summarily dismisses the application for review in accordance with the procedure provided for in Article 7 of its rules.
Madame Marlène Plachy a formé un troisième recours en exécution du jugement 2551 et un recours en exécution du jugement 3637 contre l'Union internationale de télécommunications, UIT. Le tribunal a joint le recours. Le tribunal considère que l'UIT, ayant fourni les preuves écrites qu'elle avait versé à la requérante la totalité des sommes dont le paiement avait été ordonné, et s'étant ainsi acquitté des obligations qui lui incombent en vertu des jugements 2551 et 3637, les recours en exécution sont dénués de tout objet et le litige est définitivement clos.
Pour les motifs exposés dans le jugement 3724, le tribunal a rejeté les recours en exécution conformément à la procédure sommaire prévue à l'article 7 de son règlement.
Mr. Suresh Chandra Raj has filed a complaint against the United Nations Industrial Development Organization, UNIDO. The complainant challenges the disciplinary measures imposed on him following an investigation into alleged misconduct. The tribunal examined each of the 7 grounds of the complaint and determined them to be unfounded. It considered that the Joint Appeals Board was entitled to look at the totality of the evidence of the complainant's conduct and decided whether he had misconducted himself by abusing his authority and damaging UNIDO's reputation. There was ample evidence from which to find that there was misconduct beyond reasonable doubt in relation to the charges of abuse of authority and damaging UNIDO's reputation.
For the reasons explained in Judgment 3725, the Tribunal dismissed the complaint.
Ms. Ina Rusu has filed a complaint against the International Organization for Migration, IOM. The complainant challenges the decision to dismiss her claim for compensation on account of labor exploitation and compulsory labor, contrary to the ILO Forced Labor Convention. She argues that she was assigned additional tasks corresponding to a higher grade. The Tribunal recalled its case law according to which the ILO conventions do not apply to the relationships between an organization and its officials. However, the Tribunal examined these claims as the prohibition of forced labor is one of the fundamental principles and rights at work. Concerning the additional tasks, they were assigned by the complainant's supervisor purportedly on the basis of a standard clause in the terms of reference, which required the complainant to perform other related tasks assigned by her supervisor. While the Tribunal does not find the general nature of that clause illegal, it considers that the IOM administration should have been aware that such a clause permits it to assign only such additional tasks and responsibilities to the complainant as were compatible with her G5 grade. The Tribunal considers, and IOM has not disputed, that the 5 subject tasks that were assigned to the complainant occasioned her to perform duties and responsibilities which were above her grade. An international organization is required to respect the grading structure and grades of its staff members. The Tribunal therefore determines that the complainant is entitled to material damages for the tasks that she performed above her grade, and that she is entitled to moral damages for the prejudice that she suffered by IOM's breach.
For the reasons explained in Judgment 3726, the Tribunal decides as follows. IOM shall pay the complainant 50,000 United States dollars in material damages. IOM shall pay the complainant 10,000 United States dollars in moral damages. IOM shall pay the complainant 1,000 United States dollars in costs. All other claims are dismissed.
Mr. Peter Ries-Gildea has filed a 4th complaint against the International Federation of Red Cross and Red Crescent Societies. The complainant, whose post was abolished following a restructuring exercise, challenges the new final decision taken by the Secretary General pursuant to Judgment 3208 concerning his 2nd complaint. In analyzing the explanation of the Secretary General, the Tribunal considered that it is not sufficient to explain why, in the opinion of the executive head of an organization, the internal appeals body approached an issue in a way that was flawed. It is also necessary to explain the basis on which the conclusion actually reached by the executive head of the organization was arrived at, if it was different to the conclusion of the internal appeal body. Accordingly, the explanation provided in the impugned decision does not meet the requirements of the Tribunal's jurisprudence. The Tribunal considers that the Federation bore the onus of showing that the complainant was not able to remain in the Federation service in some capacity, and a much more active role was required of it in circumstances where a long-serving member of staff towards the end of his career was facing the prospect of his employment being terminated because of redundancy. The Federation failed in its duty towards the complainant, and in this respect, the complainant is entitled to moral damages.
For the reasons explained in Judgment 3727, the Tribunal decides as follows. The Federation shall pay the complainant 66,000 Swiss francs as moral damages within 30 days of the public delivery of this judgment. The Federation shall pay the complainant 6,000 Swiss francs as costs within 30 days of the public delivery of this judgment. Interest shall accrue at the rate of 5% per annum on the above amounts for any period in which the amounts required to be paid by orders 1 and 2 remain unpaid after 30 days from the public delivery of this judgment. All other claims are dismissed.
Ms. Diala Chekade has filed a complaint against the International Criminal Court, ICC. The complainant challenges the abolition of her post and the non-renewal of her fixed-term contract. The tribunal noted that under the applicable administrative instruction, the benefit of a 3-year extension arose only if there was a continuing need for the post, and the complainant has not demonstrated there was such a need. The tribunal also rejects the complainant's contention that adequate steps were not taken by the court to find another position for the complainant within the ICC.
For the reasons explained in Judgment 3728, the Tribunal dismisses the complaint.
Ms. Arlette Eleanor Bergdorf has filed a complaint against the Permanent Court of Arbitration, PCA. The complainant challenges the term on which her appointment was terminated. She was told that she had breached the Secretary General's trust by disclosing confidential information to another staff member. The tribunal reviewed the complainant's argument that the decision to terminate her appointment was unlawful principally because she was not provided with the reasons or given the right to defend herself and found neither correct. The tribunal rejected the PCA's objection to the receivability of the complaint as it was not raised in the internal appeal and cannot be relied upon for the first time before the tribunal.
For the reasons explained in Judgment 3729, the Tribunal dismisses the complaint.
Monsieur Laurent Prinsen a formé une requête contre l'Organisation européenne pour la sécurité de la navigation aérienne, Eurocontrol. Le requérant reproche à Eurocontrol de lui avoir retiré son titre et ses fonctions de chef de section. Le tribunal considère que même si les greffes soulevées par le requérant sont manifestement dépourvues de fondement, celui-ci a été indûment maintenu pendant une période excessive dans une position illusoire qui a incontestablement pu porter une atteinte relativement importante à sa dignité et qu'il a subi du fait de cette situation un préjudice moral qui doit être réparé.
Pour les motifs exposés dans le jugement 3730, le tribunal décide ce qui suit. Eurocontrol versera au requérant une indemnité de 15 000 € à titre de dommages et intérêts pour tort moral. Elle lui versera également la somme de 4 000 € à titre de dépens. Le surplus des conclusions de la requête est rejeté.
Mr. Rudy Vermes has filed an application for interpretation and execution of Judgment 3235 against the Organization for the Prohibition of Chemical Weapons, OPCW. The complainant asks the tribunal to clarify whether Judgment 3235 requires the OPCW to pay further material damages, to order such payment if required, and to clarify other aspects of its judgment and to award costs. On the question of reinstatement, the tribunal considers that an order which merely sets aside a decision dismissing an appeal against a decision terminating an official's employment does not, of itself, and in particular without an order expressly reinstating the official, constitute an order which does reinstate the official. The tribunal recalls that the order dismissing the complainant's internal appeal against the decision to terminate his employment was set aside. That was coupled with an order remitting the matter to the OPCW for further consideration. The clear import of these two orders was that the Director General had to make a fresh decision about whether to dismiss the internal appeal or allow it in whole or in part. What the Tribunal intended was that when a fresh decision was made in relation to the internal appeal, and if that decision was again to dismiss the appeal, all other arguments raised by the complainant in those proceedings, which gave rise to judgment 3235, and the relief sought in consequence of these arguments could be raised afresh in any further challenge to the new decision dismissing the internal appeal in the tribunal. It was certainly not the tribunal's intention to extinguish such enforceable rights as the complainant may have had in relation to his employment and its termination, and the orders made did not have that legal effect.
For the reasons explained in judgment 3731, the tribunal decides as follows. Properly interpreted, the orders made in judgment 3235 do not preclude the complainant challenging the legality of the decision to terminate his employment and, if successful, being afforded relief by way of material and or moral damages or otherwise. Did not reinstate the complainant, the OPCW shall pay the complainant costs in the sum of 5,000 euros. All other claims are dismissed.
Mr. Didier Guionnet has filed a second complaint against the Universal Postal Union, UPU. The complainant challenges the decision to dismiss his allegation of harassment and abuse of authority as unfounded. In particular, the complainant argues that one member of the Joint Appeals Committee, GAC, should have been disqualified from the consideration of his appeal because this person had also been interviewed by the internal auditor during the investigation of his harassment complaint. The tribunal considers that the complainant's argument that the GAC composition was improper is founded. It is of the opinion that the contested GAC member could not be a member of the GAC assessing the complainant's appeal if he had been interviewed by the internal auditor, since the GAC had to assess the testimonies on which the internal auditor's report was based. His impartiality may be open to question, as there are reasonable grounds for concluding that there was an actual conflict of interest, not merely a perceived conflict. The tribunal also considers that to respect the complainant's right to be provided with sufficient material to make the case against him and to prosecute his appeal, the GAC should have offered a summary of the evidence to the complainant. The document actually provided by the Director General, in effect the executive summary of the report, is not sufficiently detailed. Accordingly, the GAC erred in the approach it adopted.
For the reasons explained in judgment 3732, the tribunal decided as follows. The impugned decision is set aside. The case is sent back to the UPU for a new decision of the Director General taken after recommendation by a new properly composed GHC in accordance with consideration 3 and 6 of the judgment. The UPU shall pay the complainant moral damages in the amount of 6,000 euros. It shall also pay him costs in the amount of 4,000 euros. All other claims are dismissed as in the UPU's counterclaim for costs.
Mr. Gerhard Rochacz has filed a complaint against the International Atomic Energy Agency. The complainant challenges the decision dismissing his two internal appeals on health-related compensation claims. The Tribunal considers that there has been no administrative decision upon which an internal appeal could be maintained rejecting a claim for damages based on negligence. It was thus open to the Director General in the impugned decision to reject the appeal on this footing.
For the reasons explained in Judgment 3733, the Tribunal dismisses the complaint.
Ms. Herta Schener has filed a seventh complaint against the International Atomic Energy Agency, IAEA. The complainant challenges this IAEA's decision not to pay her compensation for the loss of earning capacity beyond the age of 60. The Tribunal considers that IAEA's interpretation of Article 20A is fundamentally flawed, as it is based solely on the meaning of the words loss of earning capacity. Article 20A establishes the duration of the entitlement to compensation in cases where the loss of earning capacity is determined to be total. It provides that an official is entitled to this compensation from the date on which payment ceases and, quote, for as long as the disability continues, end quote. The provision is clear and unambiguous. The entitlement to compensation is contingent on the presence of the disability only. Moreover, if the drafters of the provision had intended that the entitlement to the payment of the compensation terminate upon reaching the age of retirement, it would have been explicitly stated. As the Director General's decision is grounded on an erroneous interpretation of Article 20A, it will be set aside.
For the reasons explained in Judgment 3734, the Tribunal decided as follows. The Director General's 2 October 2013 decision is set aside, as are his earlier decision of 8 July 2013 and 24 May 2013. The IAEA shall pay the complainant moral damages in the amount of 7,000 euros. The IAEA shall pay the complainant costs in the amount of 4,000 euros. All other claims are dismissed.
Ms. Herta Schener has filed a 12th complaint against the IAEA. The complainant challenges the Director General's decision to recognize her illness as possibly related to the service-incurred injuries, which she sustained on previous occasions. The Tribunal considers that, as it cannot be said that the contested letter in any way altered the earlier decisions, provided further justification for decision, or was related to different issue, the letter in question was not a new administrative decision subject to challenge. Additionally, as the complainant did not challenge the earlier decision, her request was clearly time-barred.
For the reasons explained in Judgment 3735, the Tribunal dismissed the complaint.
Monsieur Hugo de Grotte et Monsieur Pierre Jonner ont formé des requêtes contre l'Union internationale des télécommunications, UIT. Le tribunal a joint les requêtes. Les requérants contestent la décision de l'UIT de changer le régime d'assurance maladie et d'augmenter les cotisations auxquelles ils sont assujettis au titre de cette assurance. Ils soutiennent notamment que l'ordre de service sur la base duquel ont été prises les décisions litigieuses était illégal. Le tribunal rappelle que lorsqu'un texte prévoit la consultation d'un organe de représentation de personnel avant la prise d'une décision, l'autorité compétente est tenue de suivre cette procédure, sauf à entacher la décision d'illégalité. Or, l'UIT n'a pas soumis l'ordre de service litigieux à la consultation du Conseil de personnel et celui-ci est ainsi entaché d'illégalité. Les requérants ont donc droit à l'indemnisation du préjudice moral que leur a causé l'illégalité de prélèvements indus.
Pour les motifs exposés dans le jugement 3736, le tribunal décide ce qui suit. Les décisions de faire prélever sur la pension des requérants les cotisations supplémentaires à compter du 1er mai 2014 sont annulées. L'UIT est condamnée à rembourser à chacun des requérants le montant des cotisations supplémentaires indûment prélevées sur leur pension. Elle versera à chacun des requérants une indemnité pour temps moral de 2 000 €. Elle versera également à chacun d'eux une somme de 2 000 € à titre de dépens. Le surplus des conclusions des requêtes est rejeté.
Monsieur John Simpson a formé une première et une troisième requête contre l'Union internationale des télécommunications, UIT. Le tribunal a joint les requêtes. Le requérant, ancien fonctionnaire de l'UIT, soutient qu'il a été victime de harcèlement moral et d'abus de pouvoir de la part de son ancien supérieur hiérarchique, le directeur de BDT, et du secrétaire général de l'organisation. Après avoir écarté diverses fins de non-recevoir formulées par l'UIT, le tribunal a examiné si la plainte de requérant concernant le directeur du BDT a été introduite dans le délai requis. Le tribunal rappelle que c'est à l'expéditeur d'un document qu'il incombe d'établir, en cas de contestation à ce sujet, la date à laquelle son destinataire en a eu communication. Or, l'UIT n'a pas apporté la preuve nécessaire. En conséquence, c'est à tort que, par la décision du 13 mars 2014, le vice-secrétaire général a déclaré la plainte du requérant irrecevable, comme frappée de forclusion, en tant qu'elle visait le directeur du BDT, et a invité l'intéressé à circonscrire sa plainte à ces allégations dirigées contre le secrétaire général. Il en résulte que cette décision doit être annulée, de même que celle du 20 mai 2014, également fondée sur cette prétendue forclusion, par laquelle a été rejetée la demande de réexamen de la dite décision. En outre, le tribunal conclut que l'illégalité de la position ainsi adoptée par l'UIT a exercé une incidence pernicieuse sur les conditions d'examen des allégations de harcèlement moral et d'abus de pouvoir dirigées contre le secrétaire général. Le tribunal estime donc que l'instruction de la plainte dirigée contre le secrétaire général a été entachée d'irrégularité, ce qui a eu pour effet de vicier la décision du 15 octobre 2014 et d'en justifier ainsi l'annulation. Les décisions attaquées ont pour elles-mêmes causé au requérant un tort moral en ce qu'elles ont porté indûment atteinte au droit de l'intéressé à voir sa plainte pleinement et régulièrement examinée et ont eu pour effet de retarder le règlement définitif du présent litige, ce qui justifie l'octroi au requérant d'une indemnité.
Pour les motifs exposés dans le jugement 3737, le tribunal décide ce qui suit. Les décisions attaquées en date des 13 mars, 20 mai et 15 octobre 2014 sont annulées. L'affaire est renvoyée devant l'UIT afin que la plainte formée par le requérant le 20 février 2014 soit pleinement et régulièrement examinée dans les conditions prévues par l'ordre de service numéro 0505 du 16 mars 2005. À cet effet, l'organisation constituera dans un délai de 30 jours à compter du prononcé du présent jugement une nouvelle commission d'enquête qui aura la charge d'instruire cette plainte. L'Union versera au requérant une indemnité pour tort moral de 7 000 €. Elle lui versera également la somme de 5 000 € à titre de dépens. Le surplus des conclusions des requêtes est rejeté.
Monsieur John Simpson a formé une deuxième requête contre l'UIT. Le requérant attaque la décision portant au rejet de sa demande de versement d'une indemnité de licenciement. La demande a été rejetée pour forclusion. Le tribunal constate que l'UIT n'apporte pas la preuve, ce qui lui incombe, que la date à laquelle le requérant a eu effectivement connaissance du contenu du courriel en cause. Le tribunal considère que c'est à tort que, par la décision attaquée, la demande de rappel d'indemnité de licenciement et de réparation de préjudice moral présentée par le requérant a été rejetée pour forclusion, alors qu'il lui a appartenu au secrétaire général d'en examiner la bien fondée.
Pour les motifs exposés dans le jugement 3738, le tribunal décide ce qui suit. La décision attaquée en date du 24 mars 2014 est annulée. L'affaire est renvoyée devant l'UIT afin que soit prise dans un délai de 30 jours à compter du prononcé du présent jugement une nouvelle décision statuant sur les mérites de la demande de rappel d'indemnité de licenciement et de réparation de préjudice moral présentée par le requérant le 18 février 2014. L'Union versera au requérant une indemnité pour tort moral de 3 000 €. Elle lui versera également la somme de 2 000 € à titre de dépens. Le surplus des conclusions de la requête est rejeté.
Mr. Fabio Bancivenga has filed a complaint against the International Fund for Agricultural Development, IFAD. The complainant challenges changes to the IFAD General Service Staff Salary Scale as a result of the implementation of recommendations contained in an International Civil Service Commission report in 2012 on local employment conditions in Rome. The tribunal notes that the complainant challenged the lawfulness of the changes solely on the ground that they were based on the ICSC's August 2012 allegedly unlawful decision, which in turn was based on an illegal survey and underlying illegal methodology. It considers that these submissions and arguments are irrelevant in the circumstances, given that the new salary scale was not applied to the complainant. In fact, the complainant's salary was subject to a freeze, which was a measure IFAD decided to adopt from many options for implementation of the ICSC recommendation. The complaint relying on the payroll is therefore receivable because the salary freeze was liable to cause the complainant's financial injury. However, as he did not advance any submissions or arguments regarding the legality of the salary freeze, the tribunal is left with no option but to dismiss the complaint.
For the reasons explained in Judgment 3739, the tribunal dismissed the complaint.
Mr. Paolo Barchiesi, Ms. Luigia Sforza, and Ms. Stefania Tarantini have filed a complaint against the Food and Agriculture Organization of the United Nations, FAO. The tribunal joined the complaints. The complainants challenged the legality of changes in the FAO General Service Staff Salary Scale as a result of the implementation of recommendations contained in an ICSC's report in 2012 on local employment conditions in Rome. The tribunal notes that the complainants challenged the lawfulness of the change solely on the ground that it was based on the ICSC's August 2012 allegedly unlawful decision, which in turn was based on an illegal survey and underlying illegal methodology. It considers that these submissions and arguments are irrelevant in the circumstances, given that the ICSC's revised salary scale recommendation had no bearing on the complainant's position as the new salary scale was not applied to them. In fact, the complainant's salaries were subject to a freeze, which was a measure FAO decided to adopt from many options for implementation of the SCSC's recommendations. The complaints relying on pay sheets are therefore receivable because the salary freeze was liable to cause the complainant's financial injury. However, as they did not advance any submissions or arguments regarding the legality of the salary freeze, the tribunal is left with no option but to dismiss the complaints.
For the reasons explained in Judgment 3740, the tribunal dismissed the complaint.
Mr. Carlo Caponi and Mr. Marco Staffilani have filed complaints against the Food and Agriculture Organization of the United Nations, FAO, and 17 other staff members filed applications to intervene in this case. The tribunal joined the complaints. The complainants challenged the decision to cease treating the service differential as pensionable remuneration. This measure was prompted by the instruction from the UN Joint Staff Pension Fund. The complainants argue that the FAO breached its obligation to ascertain that the incorporation of this measure in its own legal order did not entail any difficulty. The tribunal concluded that the FAO was obliged to comply with the pension fund's regulation, or it risks having sanctions imposed by the fund. The tribunal also concludes that the complainants have failed to establish breaches of acquired rights, contractual rights, the principle of mutual trust, and the principle of equal treatment.
For the reasons explained in Judgment 3741, the tribunal dismissed the complaints as well as the applications to intervene.
Mr. Daoud Khan has filed a complaint against the Food and Agriculture Organization of the United Nations, FAO. The complainant contests the direct appointment of another person to a position of director. The Tribunal considers that the circumstances which the FAO provides to support its case, that it was impracticable to issue a vacancy notice and to conduct a competition for the subject post, are unconvincing, and that there is nothing which shows that an appropriate acting appointment could not have been made purely as an interim measure, pending the conduct of a competitive process to fill the post. The claim that the FAO breached its own rules when it directly appointed another person to the vacant post without a competitive process is well-founded, and the impugned decision will accordingly be set aside.
For the reasons explained in Judgment 3742, the Tribunal decides as follows. The impugned decision contained in the Director General's letter dated 8 April 2014 is set aside. The FAO shall ensure that the formerly selected candidate, Mrs. S., is shielded from any injury that may flow from the setting aside of the impugned decision and the resultant quashing of an appointment which she accepted in good faith. The FAO shall pay the complainant a total of 16,000 euros in moral damages. The FAO shall also pay the complainant 1,000 euros in costs. All other claims are dismissed.
Ms. Marie-Lucille Beverly Palihawadana has filed a complaint against Food and Agriculture Organization of the United Nations, FAO. The complainant challenges the non-renewal of her fixed-term contract. The Tribunal considers that the complainant has not provided evidence and arguments to pursue the Tribunal that the decision not to extend her contract was fatally flawed in the way discussed in the Tribunal's jurisprudence. The complainant bears the burden of proving malice, bad faith, and misuse of authority, and she has not done so.
For the reasons explained in Judgment 3743, the Tribunal dismisses its complaint.
Mr. Salvatore Sconamiglio has filed a complaint against the Food and Agriculture Organization of the United Nations, FAO. The complainant challenges the FAO's decision to terminate his appointment for health reasons. The Tribunal is satisfied on the evidence that the complainant was not incapacitated for further service, which would entitle him to the incapacity procedures, and the FAO made reasonable efforts to find suitable alternative posts to which to redeploy the complainant, and that it did not err by initiating the termination procedure.
For the reasons explained in Judgment 3744, the Tribunal dismisses the complaint.
Mr. Salvatore Sconamiglio has filed a second complaint against the FAO. The complainant challenges the FAO's refusal to recognize his partial permanent impairment as service incurred and to award him compensation corresponding to the rate of that impairment. The Tribunal determines that the claim in the present complaint, which seeks to challenge the decision concerning the degree of the complainant's permanent impairment, is irreceivable under Article 7, Paragraph 1 of the Tribunal Statute, as is his claim for breach of duty of care. In any event, it considers that the complainant's claim, which seeks to challenge the decision on degree of his permanent impairment and for related compensation, is unfounded.
For the reasons explained in Judgment 3745, the Tribunal dismisses the complaint.
Monsieur Théophik Beniaya a formé une requête contre l'Organisation mondiale de la propriété intellectuelle, OMPI. Le requérant conteste le non-renouvellement de son contrat de durée déterminée suite à un congé de maladie prolongé. Le tribunal rappelle sa jurisprudence en vertu de laquelle le fonctionnaire au bénéfice d'un contrat de durée déterminée ne peut se prévaloir d'un droit au renouvellement de ce contrat à son échéance. Les organisations internationales ne doivent pas moins justifier leur décision de non-renouvellement d'un contrat de durée déterminée. En l'espèce, la décision de non-renouvellement de juin 2012 reposait sur le fait que le requérant avait lui-même indiqué qu'il ne pourrait reprendre ses fonctions avant le 1er septembre 2012. La défendresse a accordé à 2 reprises au requérant, pour 6 mois au total, le bénéfice d'un congé spécial pour maladie prolongée, traitement exceptionnel prévu par le règlement du personnel. Le tribunal considère qu'au vu des circonstances de l'espèce, l'incertitude dans laquelle le requérant a laissé l'organisation quant à la date de son retour à son poste constituait une raison objective de ne pas renouveler son contrat à son échéance. On ne saurait donc rapprocher au directeur général d'avoir abusé de son pouvoir d'appréciation.
Pour les motifs exposés dans le jugement numéro 3746, le tribunal rejette la requête.
Mr. Rodrigo Garcia Conde has filed a complaint against the World Intellectual Property Organization, WIPO. The complainant challenges the decision not to select him for a post. The WIPO Appeals Board recommended that the appointment of the successful candidate be annulled. The tribunal concludes that the complainant's claims are not moot insofar as the Director General, who did not follow the Appeals Board recommendations, decided not to annul the competition and to award the complainant 500 Swiss francs in moral damages. However, regarding the Director General's decision to maintain the competition, the tribunal finds that the complainant's claim is founded. The Appeals Board obviously recommended that the competition be annulled. The flaws identified in the selection process would ordinarily warrant remitting the matter to WIPO in order for the Director General to take a new decision. In the present case, it is unnecessary to make such an order because the decision of the new competition is now immune from challenge. However, the complainant is entitled to moral damages as a consequence of the flaws identified in the tribunal.
For the reasons explained in Judgment 3747, the tribunal decides as follows. WIPO shall pay the complainant moral damages in the amount of 20,000 Swiss francs. WIPO shall also pay him costs in the amount of 5,000 Swiss francs. All other claims are dismissed.
Ms. Deborah Boland has filed a complaint against the Global Fund to fight AIDS, tuberculosis, and malaria. The complainant contests the Global Fund's decision to withdraw an offer of employment allegedly made to her by the fund's chief procurement officer in retaliation for her grievance filed against the Global Fund regarding the fact that she was not shortlisted for a post. The tribunal is not satisfied that the complainant has demonstrated that the conduct of the chief procurement officer or, for that matter, the senior advisor HR policy and employee relations or any other official in the HRD was motivated by malice or any other improper or inappropriate reasons, such as to constitute unlawful retaliation, and considers that she has not demonstrated that the Global Fund engaged in unlawful retaliatory conduct towards her.
For the reasons explained in Judgment 3748, the tribunal dismisses the complaint.
Madame Annabella Esteves dos Santos a formé une requête contre le Fonds mondial de lutte contre le sida, la tuberculose et le paludisme. La requérante demande le remboursement de suppléments d'impôt sur le revenu payé au fisc genevois par son époux qui n'était pas fonctionnaire international. Le tribunal note qu'il s'est déjà prononcé sur une question analogue dans son jugement 3020 impliquant l'Organisation mondiale du commerce. En examinant une fin de non-recevoir, le tribunal a rappelé qu'au terme de son statut, une requête n'est recevable que si la décision attaquée est définitive, l'intéressé ayant épuisé tout moyen de recours mis à sa disposition par le statut de personnel. La jurisprudence a précisé que, pour satisfaire à ces dispositions, le requérant doit non seulement suivre la procédure de recours interne, mais la suivre exactement et notamment respecter les délais éventuellement fixés au fin de cette procédure. Or, en l'espèce, le tribunal constate que le requérant a entrepris la décision en question par la voie d'une demande de résolution de différend après l'expiration du délai de 90 jours prévu par le règlement et que c'est donc à juste titre que cette demande a été rejetée comme irrecevable pour tardiveté.
Pour les motifs exposés dans le jugement 3749, le tribunal rejette la requête.
Ms. Sharon N. Fernandez has filed a complaint against the World Health Organization, WHO. The complainant, a former WHO staff member, challenges the decision to abolish her post and to terminate her fixed-term appointment. The tribunal considers that it was not for the complainant to have to discern the reasons why her post had been abolished and the reasons why she had not been matched to a new position. It was incumbent on WHO to provide those reasons, both as a matter of fairness and also to safeguard the complainant's rights to contest the decision. WHO's failure to provide those reasons entitles the complainant to moral damages.
For the reasons explained in judgment 3751, the tribunal decided as follows. WHO shall pay the complainant 10,000 Swiss francs by way of moral damages. WHO shall pay the complainant 700 Swiss francs in cost. All other claims are dismissed.
Mr. Douglas Horsford has filed a complaint against the World Health Organization, WHO. The complainant, a former WHO staff member, challenges the decision to abolish his post and to terminate his continuing appointment. The tribunal considers that the creation of NPO posts by WHO as part of the new structure, with the requirement that they be filled locally, either would or should have been understood by senior management as derogating from the rights of appropriately qualified staff whose position would be abolished in the new structure to obtain another position through the matching process or through the reassignment process, and diminishing the obligation of WHO to facilitate that outcome. Accordingly, the actions of WHO in creating those positions as NPO positions had the direct effect of diminishing the rights of the complainant to secure further employment within WHO, particularly through the matching process, for which the complainant is entitled to damages both moral and material.
For the reasons explained in judgment 3752, the tribunal decides as follows. WHO shall pay the complainant by way of material damages a sum of 120,000 Swiss francs, less any amounts paid to the complainant as a result of the impugned decision. WHO shall pay the complainant 25,000 Swiss francs by way of moral damages. WHO shall pay the complainant 4,000 Swiss francs costs. All other claims are dismissed.
Mr. Alim Khan has filed a complaint against the World Health Organization, WHO. The complainant, a former WHO staff member, contests the decision to terminate his fixed-term appointment pursuant to the abolition of his post. The tribunal considers that the manipulation of the position description by defining a number of criteria and the selection process denied the complainant a fair and reasonable opportunity to obtain an appointment to a new position as part of the restructuring process. Though the tribunal acknowledges that there was no certainty he would have been appointed to a post. Nonetheless, the complainant is entitled to significant material damages.
For the reasons explained in judgment 3753, the tribunal decides as follows. WHO shall pay the complainant 70,000 Swiss francs by way of material damages, less any amounts paid to the complainant as a result of the impugned decision. WHO shall pay the complainant 15,000 Swiss francs by way of moral damages. WHO shall pay the complainant 8,000 Swiss francs costs. All other claims are dismissed.
Mr. Trung Le Minh has filed a complaint against the World Health Organization, WHO. The complainant, a former WHO staff member, challenges the decision to terminate his continuing appointment pursuant to the abolition of his post. The tribunal considers that the complainant has established to the tribunal's satisfaction a flaw in the reassignment process that potentially had the result that he did not secure another position within WHO in the face of the abolition of the position he then held. The complainant lost the opportunity of maintaining continuing employment and, in this respect, is entitled to material damages.
For the reasons explained in Judgment 3754, the Tribunal decided as follows. WHO shall pay the complainant 120,000 Swiss francs by way of material damages. WHO shall pay the complainant 15,000 Swiss francs by way of moral damages. WHO shall pay the complainant 8,000 Swiss francs costs. All other claims are dismissed.
Monsieur Cyril Perviac a formé une requête contre l'Organisation mondiale de la santé, OMS. Le requérant conteste la décision de résilier son engagement continu suite à la suppression de son poste. Le tribunal relève que le requérant n'a pas contesté immédiatement la décision de supprimer son poste, mais ne l'a critiqué qu'accessoirement à celle portant résiliation de son engagement. Sur ce point précis, la requête est donc irrécevable pour non-épuisement de moyens de recours interne. Toutefois, le tribunal rappelle que les organisations internationales doivent assumer des obligations à l'égard des agents dont elles se voient contraintes de supprimer le poste. En effet, les organisations internationales ont certes le droit de restructurer leurs activités, de supprimer les postes si cela s'avère nécessaire, et partant de mettre fin à l'engagement de leurs fonctionnaires touchés par la restructuration qu'elles envisagent. Mais elles ne sont nullement légitimées à résilier purement et simplement le rapport de service de ceux-ci, de moins s'ils ont été nommés pour une durée indéterminée, avant d'avoir pris les dispositions appropriées pour leur procurer un nouvel emploi. Lorsqu'une organisation est amenée à supprimer un poste occupé par un membre de personnel qui est titulaire d'un contrat à durée indéterminée, elle a par conséquent le devoir de s'efforcer, dans toute la mesure du possible, d'assurer la réaffectation prioritaire de l'intéressé à un autre emploi correspondant à ses capacités et à son grade. Le fonctionnaire concerné peut donc exiger d'être nommé à toute fonction vacante s'il est en mesure de remplir convenablement quelles que soient les aptitudes d'autres candidats. Dans l'hypothèse où la recherche d'un tel emploi s'avérait infructueuse, il appartient même à l'employeur, pour autant que l'intéressé l'accepte, de chercher à le reclasser dans des fonctions d'un grade inférieur et d'étendre les investigations en conséquence. Or, en l'espèce, le comité de réaffectation n'a pas communiqué régulièrement avec le requérant, ne l'a pas tenu informé correctement de recherches entreprises en vue de sa réaffectation. Il en résulte que le requérant n'a pas eu concrètement la possibilité de participer à la procédure de réaffectation et qu'en se comportant comme elle a fait, la défendresse a violé ses devoirs. Enfin, le tribunal estime que l'organisation n'a pas traité le recours interne de requérant avec la célérité et la diligence qui s'imposaient, un délai de 2 ans environ n'étant manifestement pas raisonnable au regard de l'ensemble des circonstances de l'espèce. Il en résulte que tant la procédure de réaffectation que la procédure de recours interne ont été affectées de divers vices qui ont causé au requérant un préjudice moral que l'OMS devra réparer.
Pour les motifs exposés dans le jugement 3755, le tribunal décide ce qui suit. L'OMS payera au requérant une indemnité de 80 000 francs suisses en réparation du dommage matériel qu'il a subi. Elle payera au requérant une indemnité de 15 000 francs en réparation du préjudice moral qui lui a été causé. Elle versera également au requérant une somme de 8 000 francs à titre de dépens. La requête est rejetée pour le surplus.
Mr. Alan Robert White has filed a complaint against the World Health Organization, WHO. The complainant, a former WHO staff member, challenges the decision to abolish his post and to terminate his fixed-term appointment. The tribunal finds a flaw in the decision-making process relating to a performance appraisal and considers that the flaw in the process concerning the reprofiling in the complaints meant that he was denied the real possibility of further employment with WHO, and the damages decided upon by the Director General were inadequate.
For the reason explained in Judgment 3756, the Tribunal decides as follows. WHO shall pay the complainant 60,000 Swiss francs as material damages offset by any amounts already paid pursuant to the impugned decision to pay the complainant 25,000 Swiss francs. WHO shall pay the complainant 28,000 francs by way of moral damages. WHO shall pay the complainant 8,000 francs costs. All other claims are dismissed.
Monsieur Hassan Ouedraogo a formé une requête contre l'Organisation mondiale de la santé, OMS. Le requérant conteste la décision de le révoquer immédiatement pour faute. Il a été accusé par un entrepreneur d'irrégularités financières liées à une procédure de passation de marché. Le tribunal estime que le requérant ne pouvait ignorer qu'il lui était reproché d'avoir commis une faute très grave susceptible d'entraîner sa révocation immédiate. De plus, il ne saurait faire de doute que l'organisation a respecté tant les formalités requises par le règlement de personnel que l'ensemble de ses devoirs découlant du droit d'être entendu du requérant, dont le tribunal a récemment encore rappelé l'entendu en procédure disciplinaire.
Pour les motifs exposés dans le jugement 3757, le tribunal rejette la requête.
Mr. Dinesh Chandler Pathak has filed a seventh complaint against the World Health Organization, WHO. The complainant challenges his non-selection for a post. In particular, he argues that he was misled by an HR officer and his internal appeal should not therefore be considered as having been filed late. The tribunal finds that although the motivation for doing so is unknown, contrary to the opinion of HBA, the administration acted in bad faith by deliberately misleading the complainant to his detriment. It follows that an exception must be made to the strict adherence to the time limit for lodging the internal appeal against the selection decision for the post in question.
For the reasons explained in Judgment 3758, the Tribunal decides as follows. The Director General decision of 26 November 2013 is set aside and the matter is remitted to WHO for consideration by the HBA on the merits of the appeal against the selection from post number 50010. WHO shall pay the complainant moral damages in the sum of 20,000 United States dollars. WHO shall pay the complainant cost in the amount of $750. All other claims are dismissed.
Madame Vohangi Tiana Antonella Randransoa a formé une requête contre l'Organisation mondiale de la santé, OMS. La requérante conteste la décision de résilier son engagement de durée déterminée suite à la suppression de son poste. Le tribunal considère que le comité régional d'appel et le directeur régional ont induit la requérante en erreur en lui donnant à penser que la suppression du poste aux Comores, qu'elle avait attaqué correctement, et le gel du poste à Brazzaville qu'elle ne pouvait plus attaquer, ne pouvaient faire l'objet que d'un seul et même contentieux. Il en résulte que la décision attaquée repose sur un formalisme excessif. Or, en vertu de la jurisprudence du tribunal, les règles de procédure doivent être interprétées sans excès de formalisme, ce qui est le cas lorsqu'une autorité applique abusivement une règle de forme et qu'elle évite de la sorte de se prononcer sur le fond, un tel comportement se rapprochant alors du refus de statuer.
Pour les motifs exposés dans le jugement 3759, le tribunal décide ce qui suit. La décision du directeur général de l'OMS du 15 août 2014 est annulée en tant qu'elle porte sur la suppression du poste que la requérante occupait aux Comores. L'affaire est renvoyée à l'organisation pour qu'elle procède, comme il est dit, au considérant 7 du jugement. L'organisation versera à la requérante une indemnité de 4 000 francs suisses en réparation du préjudice moral que celle-ci a subi. Elle lui versera aussi la somme de 800 francs à titre de dépens. Le surplus des conclusions de la requête est rejeté.
Ms. Leslie Joan Limage has filed a fourth complaint against the United Nations Educational, Scientific and Cultural Organization, UNESCO, and 100 other staff members filed application to intervene. The complainant challenges the decision to amend the rules of the Medical Benefits Fund. In particular, she impugns the Director General's report proposing the amendments and the General Conference's resolution number 85. The Tribunal notes that the Director General's report on the action taken in response to the General Conference's instruction does not constitute an administrative decision, but is an action taken in conformity with the Director General's duties pursuant to the organization's regulations. It also notes that until the implementation of Resolution 85, it had no effect on the participants in the Medical Benefits Fund, and finds that the complaint regarding Resolution 85 does not show a cause of action.
For the reasons explained in Judgment 3760, the Tribunal dismissed the complaint as well as the application to intervene.
Mr. Georges-Jean Dupont and Ms. Mariella Richon have filed complaints against the United Nations Educational, Scientific and Cultural Organization, UNESCO. The Tribunal joined the complaints. The complainants challenge a circular that implements amendments to the rules of the Medical Benefits Fund. The Tribunal considers that, as the decision of the Director General to amend the fund's rule was not taken in compliance with the amendment provisions in those rules, and as she did not obtain the approval of the General Assembly of Participants for the amendments, the decision was therefore unlawful and will be set aside. It follows that the amendments to these rules are of no force or effect. The complainants are entitled to an award of moral damages for the organization's complete disregard of the fund's statutory provisions and the resulting unlawful decision. As the interveners are in the same position in fact and in law as the complainants, their applications to intervene are accepted and they are also entitled to moral damages.
For the reasons explained in Judgment 3761, the Tribunal decides as follows. The Director General's 21 October 2014 decision is set aside. UNESCO shall pay each complainant an intervener moral damages in the amount of 5,000 euros. UNESCO shall pay each complainant costs in the amount of 500 euros. All other claims are dismissed.
Mr. Fareshteh Ahmad Begoui and Mr. Karl Josef Wilhelm Hodggersand have filed complaints against the United Nations Educational, Scientific and Cultural Organization, UNESCO, and 33 other staff members have filed applications to intervene. The Tribunal joined the complaints. The complainants challenge a circular that implements amendments to the rules of the Medical Benefits Fund. The Tribunal considers that the impugned decision is an administrative decision which adversely affects the complainants and does not require any implementing measure. As in Judgment 3761, just pronounced, the decision to amend the fund's rules was found to be unlawful and the amendments to be of no force or effect. Therefore, the impugned decision stemming from those amendments is unlawful and must be set aside. The Tribunal finds that the interveners had not established that they are in a situation in fact and in law similar to that of the complainants.
For the reasons explained in Judgment 3762, the Tribunal decides as follows. The impugned decision of 3 November 2014 is set aside. UNESCO shall pay each complainant 5,000 euros in moral damages. UNESCO shall pay each complainant 500 euros in costs. All other claims are dismissed. The application to intervene are dismissed.
Madame Laurence Ferry a formé un recours en exécution du jugement 3505, rendu suite à la requête qu'elle avait déposée contre l'UNESCO. Le tribunal estime que même si, au jour du délibéré du présent jugement, à l'avis du Conseil d'appel n'a pas encore été rendu, la procédure d'appel a normalement suivi son cours. Et si l'on peut certes regretter que celle-ci n'ait pas été plus rapide, il convient de relever que sa durée est en grande partie imputable aux prolongations de délai sollicitées par la requérante elle-même. Le tribunal en conclut que l'UNESCO a, en l'état, correctement exécuté le jugement 3505. Toutefois, une lettre adressée à la requérante par les services de l'organisation révèle une regrettable négligence dans le traitement de son dossier. Les informations erronées qu'elle contenait étaient de nature à semer la confusion dans l'esprit de l'intéressé, et le comportement de l'UNESCO lui a ainsi causé un préjudice moral qu'il convient de réparer par l'octroi d'une indemnité.
Pour les motifs exposés dans le jugement 3763, le tribunal décide ce qui suit. L'UNESCO versera à la requérante une indemnité de 1 000 € pour tort moral. Elle lui versera également la somme de 500 € à titre de dépens. Le surplus des conclusions du recours est rejeté.
M. Elia Mathias a formé une requête contre l'UNESCO. Le requérant conteste le rejet de sa demande en vue du reclassement de son poste. Le tribunal considère que le rapport d'audit du poste, sur la base duquel est réalisé son classement, est entaché de deux vices substantiels, à savoir le défaut de signature de son auteur et de son supérieur hiérarchique, qui sont de nature à jeter un doute sur son authenticité même et sur l'exactitude de son contenu. Le tribunal estime dès lors que la décision attaquée se trouve entachée d'illégalité en raison des irrégularités affectant le rapport d'audit. Le tribunal estime que ces irrégularités ont causé au requérant un préjudice moral qu'il a lieu de réparer en lui allouant une indemnité.
Pour les motifs exposés dans le jugement 3764, le tribunal décide ce qui suit. La décision du 5 novembre 2013 est annulée. L'UNESCO versera au requérant une indemnité pour tort moral de 13 000 €. Elle lui versera également la somme de 500 € à titre de dépens. Toutes autres conclusions des parties sont rejetées.
M. Sheikna Sankare a formé une requête contre l'UNESCO. Le requérant conteste la décision de ne pas prolonger son engagement au-delà de l'âge statutaire de la retraite. Le tribunal rappelle qu'en vertu d'une jurisprudence constante, une telle décision de prolongation d'engagement au-delà de la limite d'âge continue une mesure dérogatoire de nature exceptionnelle relevant d'un large pouvoir d'appréciation du chef exécutif d'une organisation. Cette mesure ne fait ainsi l'objet que d'un contrôle restreint du tribunal, qui ne la censurera pas si elle est entachée de certains vices. Or, le requérant n'établit nullement que la décision attaquée serait entachée d'un quelconque de ces vices.
Pour les motifs exposés dans le jugement 3765, le tribunal rejette la requête.
Madame Amal Benouna a formé une requête contre l'organisation ITER. La requérante conteste la décision de résilier son contrat au cours de sa période d'essai prolongée. Le tribunal considère qu'il est manifeste que la résiliation brutale du contrat de l'intéressé, décidée le jour même où avait eu lieu un entretien houleux entre la requérante et sa supérieure hiérarchique, était la conséquence du dit entretien. Il relève qu'il était manifestement illégal de mettre un terme à son contrat avant l'échéance de la période de prolongation qui venait de lui être accordée, sans avoir préalablement procédé à une évaluation régulière de ses prestations. L'illégalité de ces décisions a en outre causé à la requérante un dommage matériel et un tort moral qu'il convient de réparer par l'allocation d'une indemnité.
Pour les motifs exposés dans le jugement 3766, le tribunal décide ce qui suit. La décision du 10 mars 2014 est annulée. L'organisation ITER versera à la requérante une indemnité de 12 000 € en réparation des préjudices subis. Elle lui versera également la somme de 4 000 € à titre de dépens. Le surplus des conclusions de la requête est rejeté.
Mr. Jeremy Keith Goff has filed a complaint against the ITER International Fusion Energy Organization. The complainant challenges the decision to delay the grant of a periodic step advancement based on his 2012 performance appraisal report. The tribunal considers that the claim in the complaint, which seeks to challenge his 2012 performance appraisal, is irreceivable, as it was lodged out of time. It also considers that the complainant did not satisfy the requirement of the Employment Development Policy concerning periodic step advancement, as his 2012 appraisal report, which is immune from challenge, did not rate him as at least meets requirements. Accordingly, his claim to set aside the decision to withhold his step increases falls.
For the reasons explained in Judgment 3767, the Tribunal dismisses the complaint.
Mr. Jeremy Keith Goff has filed a second complaint against the ITER organization. The complainant challenges the decision not to renew his contract following the abolition of his post. The Tribunal considers that the ITER organization's failure to disclose to the complainant the documents related to the staffing strategies on the grounds that they constitute confidential managerial documents was a procedural flaw. These are the documents which would have assisted the complainant to understand the actions, rationale, and decisions to abolish his post in the context of the mediation process. While the ITER organization disclosed them to the mediator, it refused to disclose them to the complainant. This was in breach of the principle of procedural fairness, as well as the organization's duty of care to the complainant, entitling him to moral damages.
For the reason explained in Judgment 3768, the Tribunal decides as follows: the ITER organization shall pay the complainant moral damages in the sum of 10,000 euros within 30 days of the date of public delivery of the present judgment. The ITER organization shall pay the complainant 750 euros in costs. All other claims are dismissed.
Mr. Masahisa Higuchi has filed a complaint against the ITER organization. The complainant challenges the decision not to renew his contract following the abolition of his post. The Tribunal considers that as the complainant's contract expired in December and the general business needs of the organization were changing, it was open to the organization to select his post for abolition. The Tribunal cannot substitute its opinion for that of the organization, which found that the complainant did not have the necessary skills, mix, and experience to fulfill the requirements of the new post. The Tribunal finds that this decision falls within the discretion of the Director General and that it is not legally flawed.
For the reasons explained in Judgment 3769, the Tribunal dismissed the complaint.
Mr. Andrei Kukushkin has filed a complaint against the ITER organization. The complainant challenges the decision not to renew his contract following the abolition of his post. The Tribunal finds that the recommendations of the mediator, endorsed by the Director General, were properly executed, and the decision to abolish the complainant's post and not to renew his contract is lawful.
For the reason explained in Judgment 3770, the Tribunal dismisses the complaint.
Madame Kinan Adamo a formé une requête contre l'Organisation internationale du travail, OIT. La requérante rapproche à l'OIT de l'avoir induite en erreur au sujet du système de promotion personnelle, faisant valoir que l'imprécision d'un courriel du département de développement des ressources humaines serait à l'origine de son choix de voir son cas examiné au regard de la seconde voie de promotion personnelle et aurait eu des conséquences négatives sur le montant de sa pension de retraite. Le tribunal estime que, contrairement à ce que soutient la requérante, le fait que ce courriel n'ait pas mentionné sa date d'éligibilité à une promotion au titre de la seconde voie ne constituait nullement une anomalie de nature à l'induire en erreur sur ce point. En outre, le tribunal relève que ce même département a diffusé en mai 2012 à tous les fonctionnaires du BIT un courriel invitant ceux d'entre eux qui pensaient remplir les conditions requises pour être éligibles à une promotion personnelle ou qui souhaitaient vérifier leur éligibilité à contacter le département. La requérante avait ainsi une nouvelle opportunité de se renseigner sur la date de son éligibilité au titre de la seconde voie, et c'est de son seul fait qu'elle n'en a pas usé.
Pour les motifs exposés dans le jugement 3771, le tribunal rejette la requête.
Monsieur Nicola Berardi a formé une requête contre l'Organisation internationale du travail OIT. Le requérant, qui est employé par le Centre international de formation de l'OIT, conteste la décision de ne pas lui octroyer un contrat sans limitation de durée. Le tribunal reconnaît le large pouvoir d'appréciation dont jouit une organisation lorsqu'elle prend une décision au sujet de la transformation d'un engagement à durée déterminée en engagement permanent. Il ne saurait substituer sa propre appréciation à celle de l'organisation appelée à se prononcer sur le mérite respectif des différents fonctionnaires à titulariser. En l'espèce, le tribunal considère que le sous-comité compétent a dûment pris en compte et évalué les critères de bonne conduite, de rendement satisfaisant, d'aptitude des fonctionnaires éligibles à la titularisation dans le cadre de l'exercice de titularisation en 2011 pour recommander ou non l'octroi aux intéressés d'un contrat sans limitation de durée. Par ailleurs, le tribunal considère que le requérant n'a pas établi que le refus de la directrice du centre de lui accorder un contrat sans limitation de durée était entaché d'une erreur susceptible d'en justifier le réexamen.
Pour les motifs exposés dans le jugement 3772, le tribunal rejette la requête.
Madame Brigitte Bissière a formé une quatrième requête contre l'Organisation internationale du travail, OIT. La requérante conteste le calcul des années de service prises en compte pour déterminer sa date d'éligibilité à une promotion personnelle. Le tribunal estime que le calcul de la durée de service d'un fonctionnaire au bénéfice de contrats de courte durée rémunérés au mois doit, comme l'avait recommandé la commission consultative paritaire de recours, s'opérer de façon identique au calcul des années de service d'un fonctionnaire titulaire d'un contrat sans limitation de durée ou de durée déterminée, c'est-à-dire sur la base de 365 jours. Dès lors, la décision attaquée n'est entachée d'aucune inexactitude. Cependant, il ressort de la jurisprudence du tribunal que les organisations internationales sont tenues de répondre aux demandes de leurs fonctionnaires dans un délai approprié. Or, en l'espèce, la requérante a saisi la défenderesse en mars 2011 pour s'enquérir de la date de son éligibilité à la promotion personnelle, et ce n'est que le 5 décembre 2012, soit plus d'une année et demie après, que la défenderesse lui a apporté une première réponse. Le tribunal est d'avis que ce retard est anormal et constitue un manquement de l'organisation à son devoir de diligence envers l'un de ses fonctionnaires et que cette situation a causé à la requérante un préjudice moral qu'il convient de réparer.
Pour les motifs exposés dans le jugement 3773, le tribunal décide ce qui suit. L'OIT versera à la requérante une indemnité de 3 000 francs suisses à titre de dommage-intérêt pour tort moral. Elle lui versera également la somme de 500 francs à titre de dépens. Le surplus des conclusions de la requête est rejeté.
Mr. Biagio Fabio Ghiazza has filed a complaint against the International Labour Organization ILO. The complainant, who worked for the International Training Center of the ILO under a number of temporary contracts, challenges the fact that he has not been offered further contracts with the center. The tribunal considers that the complainant has no standing to challenge his non-selection for a post by virtue of Article 2 of the Tribunal Statute, because he was no more than an outside applicant and could not claim the non-observance of the terms and conditions of an appointment which he did not have.
For the reasons explained in Judgment 3774, the tribunal dismissed the complaint.
Mr. Christopher Land Kazlauskas has filed a seventh complaint against the International Labour Organization ILO. The complainant, acting in his personal capacity as an ILO official and in his capacity as chairperson of the Staff Union Committee, challenges the lawfulness of the Office Procedure number 297 on rental and car advances for internationally recruited officials, as the Staff Union was not consulted before it was issued. The tribunal considers that in this case no norms providing for the consultation of the staff union have been violated. In fact, there is no provision in the rules which require the treasurer and financial controller to consult the staff union prior to issuing the office procedure in question. In the absence of any violation of a right conferred on the complainant by the relevant provisions, he has no cause of action.
For the reasons explained in Judgment 3775, the tribunal dismissed the complaint.
Ms. Catherine Rothwell has filed a complaint against the International Labour Organization, ILO. The complainant contests the decision preventing her from receiving a merit-based increment. The Tribunal considers that Article 6.5 of the Staff Regulations is the only applicable provision on which to determine this case, since the recommendation for the award of an additional increment for meritorious performance was made under it. The Tribunal finds that there is no ambiguity in this provision and that the complainant is clearly not entitled to an award by virtue of that article.
For the reasons explained in Judgment 3776, the Tribunal dismissed the complaint.
Mr. Jesus Sainz Fernandez de Marticorena has filed a first and a second complaint against the International Labour Organization ILO. The Tribunal joined the complaints. The complainant, who works for the International Training Center of the ILO, challenges in his first complaint one of his performance appraisals, and in the second complaint the decision to dismiss his allegations of harassment. The Tribunal considers that the first complaint is not receivable as the complainant received no final decision on his internal complaint challenging his performance appraisal. Regarding the second complaint, the Tribunal considers that the allegations detailed in the complaint provide a case which required further investigation and consideration and should have been referred to a commission of inquiry for the conduct of an inquiry. For this submission, the complainant will be awarded moral damages. The impugned decision will be set aside and the case remitted to the complainant's harassment complaint to be referred to a commission of inquiry.
For the reasons explained in Judgment 3777, the Tribunal decided as follows. The impugned decision dated 19 May 2014 is set aside. The complainant's first complaint is dismissed. The complainant's harassment complaint is remitted to the ILO to be referred to a commission of inquiry within 30 days after the public delivery of the present judgment. The ILO shall pay the complainant 15,000 euros in moral damages. The ILO shall pay the complainant costs in the amount of 750 euros. All other claims are dismissed.
Mr. Piero Angius has filed an 18th complaint against the European Patent Organization, EPO. The complainant mainly impugns the rejection of his internal appeal against the EPO's refusal to clarify his fiscal situation with the Dutch tax authorities. The Tribunal notes that the confusion regarding the complainant's fiscal residence between Italy and the Netherlands appears to stem mainly from the fact that the complainant was still registered as a Dutch resident from 2006 onwards. The complainant has presented no evidence that EPO misinformed the national tax authorities or that he suffered any injury stemming from the information that the EPO provided to the Dutch tax office.
For the reasons explained in Judgment 3778, the Tribunal dismissed the complaint.
Mr. Piero Angius has filed a 19th complaint against the EPO. The complainant challenges the decision to dismiss his claim for reimbursement of travel expenses and other related costs. He claims that, as he resides in Italy, he was entitled to the reimbursement of his expenses to attend a meeting in The Hague. The Tribunal considers that the status of the complaint should be determined by reference to the fact that an internal appeal was on foot and that the complainant had not exhausted his internal means of redress when the complaint was filed.
For the reasons explained in Judgment 3779, the Tribunal dismisses the complaint as irreceivable.
Mr. Piero Angius has filed a 20th complaint against the EPO. The complaint deals with the complainant's daughter's affiliation to a Dutch health insurance scheme. The Tribunal considers that the status of the complaint should be determined by reference to the fact that an internal appeal was on foot when the complaint was filed and the complainant had not exhausted his internal means of redress. The Tribunal did not accept the argument that denying him an oral hearing would be denying him due process. Quite plainly, the powers conferred on the Tribunal by Article 5 of its statute include the power to decide or decline to hold oral proceedings.
For the reasons explained in Judgment 3780, The tribunal dismissed the complaint.
Mrs. Isabelle Marie Becker de Rop has filed a complaint against the EPO. The complainant challenges the EPO's refusal to reimburse her for school fees paid in respect of 2 dependent children. The tribunal considers that the relevant provision is clear. Even if a decision pursuant to a rule is discriminatory in nature, it does not permit the application of an alternative interpretation of the provision in question. The tribunal considers that the EPO's handling of this case constitutes a serious breach of its duty of care, and that the complainant's claim for reimbursement comes within the interpretation of Article 120A of the Service Regulations.
For the reasons explained in Judgment 3781, the tribunal decides as follows. The impugned decision is set aside. The EPO shall reimburse the complainant for the school fees that she paid for the 2007-2008 school year, together with interest at the rate of 5% per annum from the due date to the date of payment. The EPO shall pay the complainant moral damages in the amount of 20,000 euros. The EPO shall pay the complainant costs in the amount of 750 euros. All other claims are dismissed.
Mrs. Andrea Dorothea Anne-Marie Bossenberg-Schwe, Mrs. Marianne Blecker, Mr. William Albert Anfol Jacques Claessens, Mrs. Kodruta Daniela Graun, Mr. Fritz-Jan Kottmann, and Mr. Alexander Rintzer have filed complaints against the European Patent Organization. The tribunal joined the complaints. The complainants contest the classification of their posts as a result of a new career system introduced in the EPO. The tribunal considered that while the complainants' claims concerning the reclassification of their posts are unfounded, the claim for moral damages for the excessive delay in the internal appeals proceedings is founded. Consistent case law holds that an unjustified duration of 4 years for the processing of an internal appeal constitutes an excessive delay. In the present case, the EPO has not justified in any way the 3-year delay between the filing of the internal appeals and the filing of its position paper.
For the reasons explained in Judgment 3782, the tribunal decides as follows. The EPO shall pay each complainant moral damages in the amount of 3,000 euros. It shall also pay costs in the total amount of 1,200 euros. All other claims are dismissed.
Ms. Florentina Kalafus has filed a complaint against the European Patent Organization EPO. The complainant, a Romanian national working in the EPO office in Munich, challenges the rejection of her application for payment of an expatriation allowance. The tribunal finds that the evidence presented by the complainant does not reasonably rebut the presumption that she was permanently resident in Germany for 3 years prior to joining the EPO for the purpose of the service regulations, or permit her to have the benefit of the exception under the service regulations or the Lamadi note. The tribunal is satisfied that the complainant's closest objective and factual links during the 3-year period immediately prior to joining the EPO were to Germany.
For the reasons explained in Judgment 3783, the tribunal dismissed the complaint.
Mr. Cyril Courtney has filed a complaint against European Patent Organization EPO. The complainant contests the calculation of his reckonable previous experience upon recruitment. The tribunal considers that the complaint is irreceivable under Article 7, Paragraph 1 of the Statute of the Tribunal, as the complainant did not exhaust the internal means of redress because he failed to lodge his internal appeal within the time limit provided for in Article 108 of the Service Regulations, and that in any event the complaint is unfounded on its merits.
For the reasons explained in Judgment 3784, the tribunal dismisses the complaint.
Mr. Wolfgang Goller and Mrs. Veronique Verdrager have filed complaints against the European Patent Organization EPO. The tribunal joined the complaints. The complainants challenge a decision of the Administrative Council introducing provision of the service regulations for permanent employees of the European Patent Office regulating the exercise of the right to strike. The Tribunal considers that the Administrative Council should have recognized it was not the competent authority at all and should have referred the request to the President. This flaw warrants setting aside impugned decisions and remitting the matter to the EPO in order for the President, as the competent authority, to take a decision on the complainant's request for review within 2 months from the date of the delivery of this judgment.
For the reasons explained in Judgment 3786, the Tribunal decides as follows. The impugned decision notified to the complainants by separate letter dated 20 January 2014 from the Chairman of the Administrative Council are set aside. The joint case, insofar as it regards the challenges to CAD 513, is remitted to the EPO so that the President may be proceed in accordance with the applicable rules as set out in consideration 9. The claims regarding the salary deduction of 17 October 2013 are dismissed. The application to intervene are rejected. All other claims are dismissed.
Monsieur Yves-Georges Augustin Geste a formé une requête contre l'Organisation européenne de brevets OEB. Le requérant conteste l'échelon qui lui a été attribué lors de sa nomination en tant que membre d'une chambre de recours et demande l'attribution de l'échelon d'entrée par l'application de la règle dite de 55 ans. Le tribunal estime tout à fait pertinent l'observation faite à l'unanimité par la commission de recours interne, selon laquelle les candidats externes qui postulent un recrutement en qualité de membre d'une chambre de recours peuvent être amenés à devoir renoncer à certains avantages dont ils bénéficient dans leurs fonctions antérieures. Le requérant qui critique la légitimité de la différence de traitement en cause n'avance cependant aucun argument concret de nature à remettre en cause ce constat. Le tribunal estime donc que la différence de traitement critiquée trouve ainsi un fondement légitime dans une différence de situation entre les deux catégories de membres de chambre de recours en rapport avec l'objet de la règle des 55 ans.
Pour les motifs exposés dans le jugement 3787, le tribunal rejette la requête.
Mr. Elias Kyranos has filed a complaint against the European Patent Organization EPO. The complainant challenges the EPO's refusal to apply its recalculation of his reckonable experience with retroactive effect to the date of his entry into service. The tribunal considers that the relevant date is not the date on which the complainant was awarded his degree, but the date on which the evaluation was made about equivalence. In the circumstances, it is determined that the complainant's Bachelor of Science degree should be considered a diploma of completed studies at university level and accredited as satisfying the first condition in Gazette 908. It is further determined that the complainant's Bachelor of Science was equivalent to a United Kingdom Bachelor's of Engineering under the Washington Accord, which was in effect at the time when the complainant joined the EPO. The complainant therefore also satisfied the second condition for the review of the calculation of his reckonable experience as set out in Gazette 908. The EPO was therefore wrong in finding that it did not have the obligation to recognize the complainant's Bachelor of Science.
For the reasons explained in Judgment 3788, the Tribunal decides as follows. The impugned decision of 3 May 2011 is set aside to the extent that it recognizes the complainant's United States Bachelor of Science degree without recognizing the obligation to do so. The calculation of the complainant's reckonable previous experience and salary must be made with effect from 1 December 2007 with all consequential salary adjustments. The EPO shall pay the complainant €6,000 in moral damages. It shall also pay him €5,000 in cost. All other claims are dismissed.
Mrs. Carola Regrotaglie has filed a complaint against European Patent Organization, EPO. The complainant has dual nationality, German and Italian, and is based in Munich. She challenges the decision not to grant her an education allowance for her 2 dependent children. The tribunal considers that it has dealt authoritatively with the issues raised in this complaint, which was filed in 2012, in judgments 3358 and 3523, which were delivered in public in 2014 and 2015. The conclusions there that only employees who are not nationals of the country where they serve are entitled to the allowance provide a complete answer to the substance of the complainant's case.
For the reasons explained in Judgment 3789, the Tribunal dismisses the complaint.
Madame Martine Ludi a formé une requête contre l'Organisation européenne des brevets OEB. La requérante, qui après avoir démissionné a choisi de rester affiliée au régime d'assurance maladie de l'OEB, demande le remboursement des frais médicaux au titre de l'article 22 du contrat collectif d'assurance. Tout en partageant l'opinion de la défenderesse selon laquelle la situation de la requérante n'était pas prévue par l'article 22 du contrat collectif d'assurance, le tribunal considère que c'est à juste titre que l'organisation a néanmoins cherché à régler la situation de l'intéressé au regard de ses dispositions et elle estime raisonnable l'interprétation de l'article 22 faite par l'OEB.
Pour les motifs exposés dans le jugement 3790, le tribunal rejette la requête.
Mrs. Valerie Marmoy has filed a second complaint against the European Patent Organization, EPO. The complainant impugns the implied rejection of her internal appeal against the EPO's refusal to recognize her medical condition as an occupational disease and to reimburse her for the relevant medical expenses which she incurred. In the course of the proceedings, she withdrew her claim for reimbursement as the amount in question had been paid by the EPO, but she maintained her claim for damages for harassment, humiliation, discrimination, undue pressure, and isolation, and added a claim for interest on arrears. The tribunal finds that this claim is irreceivable as the complainant failed to exhaust internal means of redress. It considers that there is no final decision regarding the lack of investigation into the alleged harassment, nor any final decision or implied rejections regarding the claims for damages and interest, and that they are also irreceivable.
For the reasons explained in Judgment 3791, the tribunal dismissed the complaint.
Monsieur Michel Sadoun a formé un recours en exécution du jugement 3045, rendu suite à la requête qu'il avait déposée contre l'OEB. Il demande notamment au tribunal de constater la défaillance partielle de l'OEB dans l'exécution du jugement 3045 et d'ordonner le versement d'indemnités. Le tribunal constate qu'en exécution du jugement 3045, la défenderesse s'est acquittée du paiement des sommes qu'elle avait été condamnée à verser. Toutefois, il relève que la saisine d'une nouvelle commission médicale a, pour sa part, pris beaucoup de retard et au jour du délibéré du présent jugement, soit plus de 5 ans après le prononcé du jugement 3045, celui-ci est toujours en cours d'exécution. L'organisation a donc gravement manqué à son devoir d'exécuter le dit jugement dans un délai raisonnable. Il lui appartiendra de veiller à ce que la procédure s'achève désormais dans les meilleurs délais possibles.
Pour les motifs exposés dans le jugement 3792, le tribunal décide ce qui suit. L'OEB versera une indemnité de 20 000 € requérant en titre de réparation du préjudice moral subi. L'organisation versera une somme de 500 € requérant à titre de dépens. Le surplus des conclusions du recours est rejeté.
Mr. Mohamed Shalan has filed a complaint against the European Patent Organization, EPO. The complainant challenges the decision not to grant him a dependence allowance for his mother. The tribunal considers that the complainant's assertion that the EPO introduced an additional condition, namely that the level of support must exceed 6% of the employee's basic salary plus the dependence allowance, is without foundation. The tribunal finds that it is clear and not disputed that the complainant does not meet this condition.
For the reasons explained in Judgment 3793, Tribunal dismissed the complaint.
Mr. Mohammed Shalan has filed a second complaint against the EPO. The complainant contests the calculation of his reckonable previous experience upon recruitment, as the EPO failed to recognize his Bachelor of Science degree obtained in Cairo. The tribunal considers that, inasmuch as Egypt is not a member state of the EPO, and as it has not been established that Egypt has an equivalent recognition treaty with any of the EPO member states, the EPO is not bound to recognize bachelor's degree from universities of that country as entry-level qualifications for patent examiners in the absence of adequate proof of equivalence.
For the reasons explained in Judgment 3794, the Tribunal dismissed the complaint.
Mr. Bruno Tealdi has filed a second complaint against the European Patent Organization EPO. The complainant challenges the decision not to confirm his entitlement to transfer to the EPO pension scheme the pension rights he had acquired with a pension scheme to which he belonged directly before joining the EPO. The tribunal considers that EPO was correct in treating the complainant's request as being time-barred. However, the tribunal finds that the time which elapsed between the filing of the complainant's internal appeal, the hearing before the Internal Appeals Committee, the issuance of the committee's opinion, and the notification of the impugned decision to the complainant was excessive, and the complainant is entitled to an award of moral damages on that account.
For the reasons explained in Judgment 3795, the Tribunal decides as follows: the EPO shall pay the complainant 1,500 euros in moral damages. It shall pay him 1,000 euros in costs. All other claims are dismissed.
Mrs. Melanie Jane Sarah Kotsopoulos has filed a complaint against the Global Fund to fight AIDS, tuberculosis, and malaria. The complainant appeals the implied decision to reject her claim regarding the evaluation of her performance for the year 2012. As the complainant made her claim contesting the performance appraisal in March 2013, the period of time provided for in Article 7, Paragraph 3 of the Statute of the Tribunal ended 3 years before she filed a complaint with the Tribunal. Accordingly, her complaint is time-barred and clearly irreceivable.
For the reasons explained in Judgment 3796, the Tribunal summarily dismissed the complaint in accordance with the procedure provided for in Article 7 of its rules.
Mr. Jorge Octavio Elgegren has filed a complaint against Food and Agriculture Organization of the United Nations, FAO. The complainant impugns the final decision by Director General dismissing his appeal against the decision not to extend his contract. The Tribunal considers that as the complaint was filed beyond the 90-day period provided for in its statute, it is time-barred and clearly irreceivable.
For the reasons explained in Judgment 3798, the Tribunal summarily dismisses the complainant in accordance with the procedure set out in Article 7 of its rules.
Mr. Edgar André Köslen has filed a second complaint against the Food and Agriculture Organization of the United Nations, FAO. The complainant impugns the final decision of Director General dismissing his appeal against the decision not to extend his contract. The Tribunal considers that the complaint is time-barred and clearly irreceivable.
For the reasons explained in Judgment 3799, the Tribunal summarily dismisses the complaint in accordance with the procedure provided for in Article 7 of its rules.
Monsieur Louis-Joseph Pot a formé une requête contre l'Organisation des Nations Unies pour l'éducation, la science et la culture, l'UNESCO. Le requérant attaque une décision de 18 septembre 2015 qu'il affirme avoir reçue le 20 septembre 2015. Le tribunal considère que le délai statutaire de dépôt de la requête a expiré le 19 novembre 2015. La requête ayant été déposée le 23 décembre 2015, elle est frappée de forclusion manifestement irrécevable.
Pour les motifs exposés dans ce jugement, le tribunal rejette la requête conformément à la procédure sommaire prévue à l'article 7 de son règlement.
Mr. Craig Rousson has filed a second complaint against the International Labour Organization ILO. The complainant impugns the final decision taken on his grievance. The tribunal considers that the complaint is time-barred and clearly irreceivable.
For the reason explained in this judgment, the tribunal summarily dismisses the complaint in accordance with the procedure provided for in Article 7 of its rules.
Mrs. Marianique Lenadan has filed a second complaint against the European Patent Organization EPO. The complainant appeals the final decision to reject her request for review of a decision of the Administrative Council. The tribunal considers that the complaint is time-barred and clearly irretrievable.
For these reasons, the tribunal summarily dismisses the complaint in accordance with the procedure provided for in Article 7 of its rules.
Mrs. Maria Jesus Lorenzo Varela has filed a complaint against the European Patent Organization EPO. The complainant impugns the final decision rejecting her request for review of a decision of the Administrative Council. The tribunal considers that the complaint is time-barred and clearly irretrievable.
For these reasons, the tribunal summarily dismisses the complaint in accordance with the procedure provided for in Article 7 of its rules.
Ms. Anne-Laure Villard has filed a complaint against the EPO. The complainant impugns the final decision rejecting her request for review of a decision of the Administrative Council. The tribunal considers that the complaint is time-barred and clearly irretrievable.
For these reasons, the tribunal summarily dismisses the complaint in accordance with the procedure provided for in Article 7 of its rules.
Mr. Stefan Werner has filed a second complaint against the EPO. The complainant impugns the final decision rejecting his request for review of a decision of the Administrative Council. The tribunal considers that the complaint is time-barred and clearly irretrievable.
For this reason, the tribunal summarily dismisses the complaint in accordance with the procedure provided for in Article 7 of its rules.
Mr. Michael Samples has filed a 12th complaint against the European Patent Organization. The complainant challenges the decision to reject his appeal against a warning letter concerning his performance and the subsequent confirmation of that warning alleging harassment. The tribunal considers that the complainant's allegations of harassment are entirely unsubstantiated and amount to mere assertions. Accordingly, the tribunal sees no reason to depart from its case law concerning warning letters. The complaint is therefore clearly irretrievable.
For these reasons, the tribunal summarily dismisses the complaint in accordance with the procedure provided for in Article 7 of its rules.
Mr. Hannes Senftel has filed a 14th complaint against the EPO. The complainant challenges the decision to transfer the obligation to fund the tax adjustment paid to EPO pensioners from the member states to the EPO. The tribunal considers that the complaint is no more than a collateral attack on its judgment 3426, which the complainant totally ignored in his brief, and that it is clearly devoid of merit.
For this reason, the tribunal summarily dismisses the complaint in accordance with the procedure set out in Article 7 of its rules.
Mr. Paolo Orlando Angelo Torlai has filed a 21st complaint against the EPO. The complainant challenges the decision to transfer the obligation to fund the tax adjustment paid to EPO pensioners from the member states to the EPO. The tribunal considers that the complainant tries to relitigate the tribunal's decision in judgment 3426, and that the alleged new facts he relies on are no more than speculative assertions. Moreover, the complainant does not establish any present cause of action. His complaint is therefore clearly devoid of merit.
For this reason, the tribunal summarily dismisses the complaint in accordance with the procedure provided for in Article 7 of its rules.
Mr. Brian Stephen Kankanon has filed an 8th complaint against the EPO. The complainant challenges the decision to reject his appeal against a decision of the Administrative Council, arguing that it has a direct and immediate effect on him. The tribunal already stated in judgment 3291 that this decision is a general decision that can be challenged only through impugning an individual decision. In the present case, the tribunal sees no reason to depart from this finding. Moreover, the tribunal already dismissed a similar complaint in judgment 3628. The complaint is therefore clearly devoid of merit and irretrievable.
For these reasons, the Tribunal summarily dismissed the complaint in accordance with the procedure provided for in Article 7 of its rules.
Mr. Heinrich Hahn has filed a third complaint against the EPO. The complainant challenges the decision to eliminate the ceiling on employees' contribution to sickness insurance. In Judgment 3628, the Tribunal already dismissed a similar complaint challenging the same decision on the grounds that it was directed against a general decision which had not been applied to the complainant individually and had not affected him in any way. In the present case, the Tribunal sees no reason to depart from its finding in Judgment 3628. The complaint is therefore devoid of merit.
For this reason, the Tribunal summarily dismissed the complaint in accordance with the procedure provided for in Article 7 of its rules.
Mr. Sten Hark has filed a third complaint against the EPO. The complainant challenges the rejection by the Administrative Council of his request for review of a decision amending the provision of the service regulations relating to sick leave and invalidity. The Tribunal considers that as the impugned decision is a general decision that has not been implemented individually, the complainant's request for review filed with the Administrative Council was not only premature, but was also submitted to the wrong authority. The complaint is therefore clearly irreceivable as the complainant did not exhaust the internal remedies available to him.
For this reason, the Tribunal summarily dismisses the complaint in accordance with the procedure provided for in Article 7 of its rules.
Ms. Celia Martinez Rico and Mr. Rafael Baltanas Jorge has filed complaints against the European Patent Organization. The Tribunal joined the complaints. The complainant challenged the decision to eliminate the ceiling on employees' contribution to sickness insurance. The Tribunal already dismissed a similar complaint challenging the same decision on the grounds that it was directed against a general decision which had not been applied to the complainant individually and had not affected him in any way, which is the case in the present complainants. None of the arguments put forward by the complainants would lead the Tribunal to depart from its earlier findings. The complaints are therefore devoid of merit and irreceivable.
For these reasons, the Tribunal summarily dismissed the complaints in accordance with the procedure provided for in Article 7 of its rules.
Mr. Christophe Millet has filed a second complaint against the EPO. The complaint imputes what he considers to be an implied decision to reject his internal appeal against the rejection of his request for review of a decision of the Administrative Council. The Tribunal considers that as the complainant's appeal is currently pending before the Internal Appeals Committee, he has not exhausted the internal remedies available to him and his complaint is clearly irreceivable.
For these reasons, the Tribunal summarily dismissed the complaint in accordance with the procedure provided for in Article 7 of its rules.
And the last one. Mr. René Udo has filed a complaint against the EPO. The complainant imputes the final decision rejecting his request for review of a decision of the Administrative Council. The Tribunal considers that the complaint is time-barred and clearly irreceivable.
For these reasons, the Tribunal summarily dismisses the complaint in accordance with the procedure provided for in Article 7 of its rule. Ladies and gentlemen, this brings to a close the delivery of remaining 93 judgments adopted by the Tribunal at its 123rd session. As usual, a video recording of this meeting will be made available by the end of the day on the website of the Tribunal, www.ilo.org/trib. The electronic version of all judgments will be made available today in our database Triblex on the same website. The hard copies of all original judgments will be available at the close of this meeting, as well as the translations that have already been printed. Anyone who wants to have copies may go afterwards to the registry of the Tribunal at the R1 level. The next session of the Administrative Tribunal will start on the 24th of April 2017 and will again last 4 weeks. It will declare this meeting closed as soon as I have read the same thing in French. Oh, pas juste. As I will write the same thing in French. Thank you for your kind attention. Et maintenant, dans la langue de Molière, mesdames et messieurs, ainsi prend fin le prononcé, je suis quand même plus à l'aise là, le prononcé des 93 jugements restants rendus par le tribunal lors de sa 123e session. C'est d'ailleurs plus beau. Comme d'habitude, un enregistrement vidéo de cette séance sera disponible sur le site internet du tribunal www.ilo.org/trib avant la fin de la journée. La version électronique des jugements sera également disponible dès aujourd'hui sur le site du tribunal dans la base de données Triblex. Les versions originales de tous les jugements seront disponibles à la fin de la présente séance, ainsi que les traductions déjà imprimées. Toute personne désireuse d'en obtenir une copie pourra se rendre au greffe du tribunal au niveau R1. La prochaine session du tribunal administratif commencera le 24 avril 2017 et durera, cette fois encore, 4 semaines. Je déclare ainsi close la présente séance. Merci, mesdames et messieurs, de votre attention.